Welcome back to the OMB Law Board, and it's nice to see you all back for Season 2. Season 1 was hugely successful. We're really thankful to everyone who participated and got involved and liked our podcast, commented, and we're really looking forward to Season 2. I'm Simon Bennett from OMB Solicitors today. As part of our family law series, I've got Abbi Golightly, partner here at OMB in family law. Good morning, Abbi.
Morning, Simon.
Welcome back for Season 2.
Good to be back.
So, perfect timing to talk about this, but family law is changing. There's some serious changes in 2024 and there's more to come in 25. Tell us the big ticket items.
So on the back of the significant changes we had in May last year, we had some changes in December 2024. They weren't as significant, but what is coming in June 2025 are some really big changes in some key areas of family law, mainly in the property space, but there is some procedural changes and things like that. And so, another year of some big changes for all of us seasoned family law practitioners to get used to.
Okay, well, I'm sure our listeners and viewers really want to know what are some of the biggest changes that are going to affect family law in 25?
So the changes that are due to commence on the 10th of June this year, the threefold big changes pertain to the treatment of domestic and family violence in property settlements. In that space, the court is now going to be mandated to consider the financial effect of domestic violence on a relationship and separation, and ultimately on the division of the property settlement between the parties.
Okay.
So the considerations are effectively along the lines of, well, has someone's contributions been so significantly greater because of a long history of domestic and family violence, the financial impact of circumstances where, because of one partner exhibiting coercive and controlling behaviours, they have mandated that their partner doesn't work. So no, you can't work. I need to provide. I need to be in control of those finances for the household.
Yep.
So they lose out on their, on the working history. So getting skills, abilities, accumulating superannuation, those sorts of things, as well as a need to consider when we're practically dividing outcomes for assets, it's how we can accommodate the person who's got the primary care of the children. So the impact on having to flee a relationship, leave all of those things behind, it will be balanced in ways that we're still going to get some guidance on once the changes kick in, but it will be helpful to understand how the courts are then going to treat and weigh and alter the division of assets because of domestic and family violence.
Yeah, that's a massive change, and I'm sure it will change the way that assets are divided as that law comes in.
Yeah, it's been on the back of some significant campaigning and research undertaken on the financial impacts of domestic violence post-separation.
Okay, and am I right to say there was another great change in regards to animals?
There is. So all of our pet-loving Australians, myself included,
me too,
will be extremely joyful to hear that after the 10th of June, new considerations specifically for companion animals will be brought into the Family Law Act. Now, previously, I think we've spoken about it previously, and there's been some information on our website about the manner that pets were treated prior to 10th of June, so everything till then will be the same. But after the 10th of June, our furry companions will be given a little bit more consideration in the Family Law Act.
Well, and they're nearly as important as the kids, aren't they? For some of us?
For some of us, definitely. Depends on what day of the week you get us. So now considerations along the lines of who can best provide for their pet, who has the better yard, who has the time to walk the pet, who is the pet attached to. So it's going to apply, I think, more to dogs than cats. No offence to our cat lovers, but the bond between a human and an animal is going to be given far more consideration, as well as the bond, importantly, with children and animals, because when we're looking at whom a child lives with, if they're more primarily with one parent and the child is attached to their animal, as they would be, that will be a factor that the court starts looking at when allocating possession of an animal.
Yeah, well, that's a really interesting development because animals do form such an integral part of our family and our family unit, particularly with the children, as you mentioned. So that's interesting.
Yeah, and statistically, younger Australians are accumulating pets moreover than having children. So it will be a really important change, and I think a very welcome change, because the idea of treating our pets as pieces of property that can be, allocated on a balance sheet doesn't sit well.
That's true. That's true. So any other changes that you think we should be aware of in this coming year?
Absolutely. So one of the biggest procedural changes pertains to the requirements for financial disclosure in family law matters. Financial disclosure is a bugbear for a lot of parties. Therefore, it becomes a bugbear for us as legal practitioners. Parties are obligated under the family law rules currently to provide what we call full and frank financial disclosure of all documents that could be relevant to assisting us in making a decision about the division of their assets. Stock standard stuff, bank statements, tax returns, pay slips, superannuation statements, help us put a picture together of someone's financial circumstances. And the obligation to provide that is currently under the family law rules, so the rules that were amended in 2021. And case authorities, talk to us about the serious consequences of failure to provide financial disclosure. Those consequences can extend, in the most serious of cases, to imprisonment. Very rare, but more often than not, it is the court comparing, Party A, who's provided financial disclosure, Party B has not. Where Party A says it is black and Party B says it's white, we're more likely to go with Party A, who has done what is required of them. So that expectation that's under the rules is now going to be in our legislation.
Right. And does that regulation involve both the provision of that financial information as well as the accuracy? What if there's intentional misstatement in those assets because people are trying to distort the distribution of assets?
Absolutely. So the obligation is for full and frank. So the expectation is that people are honest and transparent in their financial dealings. And often the purpose of disclosure is to enable us as lawyers to trace money. We go through the tracing exercise. We look through the bank statements. Is there regular transfers going to a bank account that hasn't been disclosed? And if that is the case, then we ask for disclosure of that bank statement or explanation of things. And from there, we can often drag in other assets that someone thought they might be clever enough to hide, but you have to be pretty clever to get past us.
You sure do. And it sounds like exciting times in family law in 2025. Abbi, thank you so much for coming in today. We really appreciate it. And thank you all to the listeners and the viewers who I'm sure found that extremely informative, as did I.
No worries. Thanks, Simon.